Hello friends. So today I've come up with a new topic, that is private complaints under section 190 and 200 of Criminal Procedure Code. What happens when a cognizable offense is committed? A serious offenses like rape, murder or dacoity or theft or cheating, such kind of outraging modesty of women, various complaints, offenses against the body or offenses against the property, such kind of offenses are committed. They usually fall into the category of cognizable and non-compoundable offenses. Cognizable are of serious nature, and non-compoundable is like there is no question of compromise. The court will not allow you to compromise in such kind of cases. So in such kind of, if such kind of crime happens, and if you go to the police station and if you report the crime to the concerned police officer, you might be the victim or someone else is the victim. In such scenario, police usually, like, they are always in the hibernation mode, they are always in sleeping mode, they don't take up the case seriously. Okay, they try to they try to always get away with it because they have to do a lot of hard work in such scenario. So they'll refuse to entertain your complaint. In such case, what can you do? In that scenario, there is a Honorable Supreme Court's Constitution 5 Judge Constitution Bench judgment called Lalita Kumari versus State of UP. In this, there is an obiter. Obiter is an observation which is binding in the entire country on each and every police station and each and every court as well. Okay, the subordinate courts like high courts and also the magistrate courts. So this third point itself in this judgment says a two-judge bench. Earlier, the two-judge bench has decided on this point, and that was carried forward to this five-judge bench judgment. So that says a two-judge bench of this court in Lalita Kumari versus State of UP and others in the year 2008, after noticing the disparity in registration of FIRs by police officers on case-to-case basis across the country, issued notice to the Union of India, the Chief Secretaries of all the states and Union territories, and Director Generals of Police and Commissioners of Police to the effect that if steps are not taken for registration of FIRs immediately and the copies thereof are not handed over to the complainants, they may move the magistrates concerned by filing complaint petitions for appropriate directions to the police to register the case immediately and for the apprehending the accused persons, to arrest the accused persons, failing which contempt proceedings must be initiated against such delinquent police officers if no sufficient cause is shown. So mind you friends, if at all a police officer is neglecting your complaint, a serious offense has been made out, and if you have given it in writing to a police officer, if he is not registering the complaint, apart from registering the complaint, you can also proceed against that police officer for committing contempt of court in the respective high court of your state. This is what this judgment says. And if you come to the last directions, the registration of FIR is mandatory under section 154 of the code. If the information discloses commission of cognizable offence and no preliminary inquiry is permissible in such situation. If you say if you go to a police station and say to the police officer, sir, in that particular area a murder has been committed, in that case he is not supposed to go and check all these things, and all those are all secondary. Straight away he has to register an FIR and then he has to go. That is what the judgment is saying. The preliminary inquiry, who did it, why did it, who done it, sort of thing should not come into picture. If the information received does not disclose a cognizable offence but indicates the necessity for an inquiry, a preliminary inquiry may be conducted only to ascertain whether cognizable offence is disclosed or not. So if at all it does not disclose a cognizable offence, then he has to inquire whether it's a cognizable or non-cognizable offence. Then thereafter he can take a call. If the inquiry discloses the commission of cognizable offence, the FIR must be registered. In cases where preliminary inquiry ends in closing of the complaint, a copy of such entry of such closure must be supplied to the first informant forthwith and not later than 1 week. It must disclose reasons in brief for closing the complaint and not proceeding further. The police officer cannot avoid his duty of registering offence if cognizable offence is disclosed. Action must be taken against the erring officers who do not register the FIR if information received by him discloses a cognizable offence. The scope of preliminary inquiry is not to verify the veracity or otherwise of the information received, but only to ascertain whether the information reveals a cognizable offence or not. So he cannot at this stage decide whether it's a false complaint or it's a true complaint. That's none of his business. If at all, whatever the content you have written in the complaint, it discloses a cognizable offense, he is duty bound to register a case. And there are certain exceptions, my dear friends. That is, in the cases of matrimonial disputes, commercial offenses like cheating and all, some kind of such kind of offenses, medical negligence cases, which are not normally up around like the section of 304A applies to this kind of things, hardly carries a sentence of 2 years, and corruption cases. So in these cases, the exceptions are there. Otherwise, it is mandatory. Okay, and there is one more catch here: the cases where there is abnormal delay or latches in initiating criminal prosecution, for example, over 3 months delay in reporting the matter without satisfactorily explaining the reasons for delay. If at all there is a delay in your complaint, you can always legitimate reasons you can jot down in the complaint, and then you can take it forward to the police officer. Otherwise, if he is not registering, then you can move a court of magistrate under section 190 and 200 of Crpc for a private complaint. And I'd like to tell you one more important aspect of the private complaints, my dear friends. That is, if you see another judgment of A.R. Antole versus respondent Ramdas Srinivas Nayak and another. This is of 1984 judgment. If I'm not, yes, this is of 1984 judgment, and this is of the ex-chief minister of Maharashtra, who was implicated in some kind of corruption case. So in that particular judgment also, you have an obiter, that's an observation which is binding in the entire country, that says it is well recognized principle of criminal jurisprudence that anyone can set or put the criminal law into motion, except where the statute enacting or creating an offence indicates to the contrary. The scheme of the Code of Criminal Procedure envisages two parallel and independent agencies for taking criminal offences to the court. My dear friends, this is very important. If at all you are thinking that it is the state only always who is the prosecutor, you are thoroughly mistaken. State is definitely a prosecutor, no doubt about it. If at all someone commits a crime, it is not against some individual. Okay, it is if a person X kills Y, then it's not said a crime committed against Y. It's a crime against the entire society. Therefore, the state comes into picture, and with the machinery of the state, the police, the courts, everything, the public prosecutors, the government leaders, they all fight for the justice for the Y. Okay, because X has killed Y. Y is the deceased, and his family, Y's family, will get the support of the entire state. This is on one hand, but thankfully, our criminal procedure code has the constitution and the criminal procedure code. They have given us wonderful remedies. What if state itself is corrupted or itself is not interested in your case, which normally happens, is a fashion nowadays, it's a trend. In such kind of scenario, whomsoever they have given this kind of provision, that's the biggest boon to the private people. You can definitely prosecute anybody if at all there is evidence, okay, in any court of law, and you can go ahead under section 190 and 200, and the court can take cognizance. That means once it will become a charge sheet, and the entire you will be the private prosecutor, and your entire evidence will be recorded, and the other party will be punished. And if at all you ask me my personal opinion, who is a better prosecutor, the state or private, I would definitely say it is the private prosecutors are better than public prosecutors. Why? Because the entire prosecution system, when it comes to the state, is very dicey, because they don't work on proper footing. They always they have vested interests, and they always they are not that sincere in most of the cases. I would not say all 100%, but 90% I would say they don't show any special or keen interest in prosecution. Okay, only except in some kind of heinous crimes they take some kind of interest, but whereas in less than 7 years or up to 7 years of crimes, they hardly show any interest. And even if it's bigger crimes also, if at all they are being managed, then you can forget the case. Okay, so in such kind of cases, like the police officers, the prosecutors, everybody, they will not do justice. Okay, and if there is the courts, they do not go with the courts know, most of the time the courts below, the high courts and the Supreme Court, they know that yes, this person, the injustice is being done at the face of him. Okay, they can easily make out, like it happened in the Jessica Lal murder case. In the lower court they have acquitted him, but when there was lot of media outrage and all, when it came to the high court, later on they have turned around that judgment and they have convicted the culprit. So it most of the times it happens when, even in the recent times also, there was a murder case which the honorable Supreme Court has acquitted, because what the courts want is evidence on record. If you don't properly adduce the evidence, there is the strong, there is very strong chance of getting acquitted. So my friends, I would like to tell you that don't be disheartened if injustice has been meted out to you. There is only way out to fight such kind of injustice and take the bull with the horn. Okay, you can fight the bull by catching its horn. The way, what I mean is, you can privately prosecute them. Okay, let me read it further for you. And the criminal procedure envisages two parallel and independent agencies for taking criminal offences to the court. One is the police and other is ourselves. Even for the most serious offences of murder, it was not disputed that a private complaint can not only be filed but can be entertained and proceeded with in accordance to law. Okay, if it is rape, murder, or 307, that is attempt to murder, such kind of heinous crimes, it has to be entertained. The court has to take cognizance of it. There is no question of not taking, provided if you give good amount of evidence. Okay, and the next is yes, locus standi of the complainant is a concept foreign to criminal jurisprudence, save and except that wherein the statute creating an offence provides for the eligibility of the complainant. Means anybody can complain. You need not be the victim. Okay, on behalf of some other victim also you can be an informant. Okay, so that is always there. So you can also set. And one more thing, the most important thing in criminal law is, anybody can set the criminal law into motion. There's no doubt about it. You can set it from anywhere else, anywhere in the country. The crime has happened in let's say in your city, but you're traveling to your hometown. You can book an FIR in your hometown and you can prosecute from there itself. And you, whenever you want, if at all there is a delay, if you are scared for some reason or something, you can always explain in the writing, and then you can make a complaint. Let's say even after a few months or whenever it is, once you have made up your mind to complain, you can always complain. And there is no limitation for heinous crimes. The crimes that attract up to above 3 years and 7 years, above 7 years, like rapes, murders, all these things like cheating and all, there is no limitation. Anytime you can come up. A person has cheated you 10 years back. If you have evidence, right now you can book an FIR against him. This is what happens usually with the celebrities. The celebrities, they're normally involved in various sexual offences 10 years back, 5 years back. But why it comes later on? Like, there is no bar, there is no legal bar, there is no limitation on that. Any time you can apply. So always remember, you can file a complaint from anywhere, any police station, any time, even after a period of a few months or so, or few days or years as well, and anyone can file it. So there are no legal bars on all these aspects. And there is one more thing, like if you want the magistrate to order a CBI inquiry, that is also like possible. If you go through the judgment of Vinubai Haribhai Malviya versus State of Gujarat, there is there's also wonderful judgment. It was a 3-judge bench judgment. Okay, and in this, like, you have an obita which permits even the CBI to conduct the investigation. And last but not the least, friends, one of my favorite judgments is Amarnath Chaube versus Union of India, which in which the Honorable Supreme Court has held that the fair investigation is a right of each and every individual by virtue of Article 14 and Article 21. Because these are the articles which will give you right to life. Right to life normally does not mean just to live. Right to life gives you a lot of privileges that one person needs to get in a society. So all these kind of things are covered. All right, my dear friends. So I hope, like, if at all you are looking for some private prosecutor, I can assure you that we at Sridhar Dayal Law Firms, we are leading private prosecutors. Okay, we can prosecute anybody like who have done injustice to you in any court of law anywhere in the country up to the honorable Supreme Court. I can assure you justice will be delivered. There's no doubt about it. It's all in how you present your case, because all that the courts nowadays unfortunately have is like they have millions of cases and very few minutes to decide. So I can say hardly if you get 5 or 10 seconds, you're great. If you just have the best point, only one best point to make before the lordships, and you can win the case. Today one of my friends have lost one case in Supreme Court of India. He hardly could get 5 seconds. Within that, the lordships have said, sorry, there is no need to interfere, it's dismissed. So I'm just giving you an example. So the straight away, what is the only point with the lordships consider such kind of points you have to present before the bench. Then there is a possibility that your petition can be admitted and relief can be granted. So the same scenario is with the high courts and Supreme Courts and the lower courts also. There is no difference now, because the lacks of pendency of cases and very less few minutes, and you can imagine per day 300, 400, 500 cases will be listed, and how many minutes they can hardly give to anybody, hardly 30 seconds, 10 seconds to 1 minute or 2 minutes. If they give you 2 minutes, then you are lucky enough. So anyhow friends, like if you have any legal advice or something that you need, you can always get back to us, and thank you for your audience.